A very good morning and welcome back to this meeting room for the final day of the ICTY Global Legacy Conference. It will be yet another enriching and long day, and I'm pleased to request your immediate attention for the discussion of today's first panel, a panel which will consider the interaction of common law and civil law procedures in the work of a tribunal, efficiency and fairness in complex international trials. This panel will be chaired and moderated by His Excellency Judge Patrick Robinson, President of the ICTY, where he has been serving since 1998 and where he has presided over many first instance trials. He now presides over a number of appeals proceedings in cases before both the ICTY and the ICTR. I'm also pleased to introduce the following panelists, and they sit from your left to your right in the order of presentation. First, Professor Klaus Kress, who is teaching criminal law and public international law at the University of Cologne in Germany, which he represented in the negotiations concerning the ICC. Then Judge Gabrielle Kirk McDonald, one of the initial 11 judges elected at the ICTY in 1993. Judge McDonald became the tribunal's president in 1997 after she had completed the tribunal's very first trial in the case of Dusko Tadic. She is holding a number of prestigious awards, and she is now serving as a judge on the Iran-US Claims Tribunal. Then we have Judge Alphons Orie, who has been a permanent judge at the ICTY since 2001, where he first appeared as a defense lawyer, also in the case of Dusko Tadic. Judge Orie is also a former justice of the Dutch Supreme Court. And finally, Professor Michele, the Vice President of the University of Florence, Italy, where he has also served as a Dean of the Law School. Professor Papa is currently visiting professor at the Columbia Law School University in New York. Thank you for listening to the panelists under the guidance of His Excellency President Robinson.
Thank you very much. As you heard, this morning's proceedings will be devoted to a consideration of the interaction of the common law and civil law procedures in the tribunal's work and the question of efficiency and fairness in our proceedings. The tribunal has made a significant contribution to the development of international criminal law, international humanitarian law, and international human rights law at both the substantive and the procedural level. This conference is examining this contribution at both levels, but this panel is primarily devoted to a consideration of the tribunal's contribution at the procedural level. It will be mainly concerned with the strategies the tribunal has devised through amendments to its rules of procedure and evidence to achieve efficiency and fairness in its proceedings, and with whether the interaction of features from the common law and the civil law systems have contributed to or have impeded that achievement. In 1945, the Nuremberg Tribunal completed the trial of 22 accused persons in about 11 months after hearing 113 witnesses and admitting some 100,000 documents. In contrast, trials at the tribunal usually last for years, with the longest lasting almost 5 years. The main reason for the difference is the larger number of witnesses in trials at the tribunal, where on average, hundreds of witnesses testify at a trial. For example, in the Slobodan Milosevic case, there were over 400 witnesses up to the time of the case's unexpected termination. By contrast, the Nuremberg Tribunal relied mainly on documentary evidence. When to the length of trials is added the cost of the tribunal's budget, and its budget for 2011 to 2012 is $289 million US dollars, one can understand the criticism that international criminal justice is long, is slow, and is expensive. But from early in its life, the tribunal had adopted procedures to expedite its proceedings. Thus, in 1999, trial chambers were given the power to require the prosecutor to shorten the estimated length of examination in chief for some witnesses, to set the number of witnesses, and to determine the time available for presenting evidence. As criticism of the slow pace of trials mounted, the tribunal in 2000 amended its rules to allow the admission of written evidence or transcripts of previous testimony in lieu of oral testimony, as long as the evidence went to proof of a matter other than the acts and conduct of the accused, a measure inspired by procedures in the civil law system. In 2003, the Security Council established a completion strategy for investigations to be completed by 2004, trials by 2008, and all work by 2010. By this time, the tribunal, in response to the mounting criticism of the length of its trials, had, in my view, become obsessed with the devising of procedures to expedite its trials. The single most important aspect of the tribunal's work did not relate to the substantive law of any of the core crimes, but rather to its rules of procedure and evidence. The single most pressing issue was not the definition of genocide or the mens rea of a crime against humanity. It was instead, what measures can the judges devise to shorten trials? It was not, of course, ideal for any court, especially one determining the liberty of the individual, to perform its judicial functions in that environment. It was against that background that in 2006, the tribunal adopted what may be considered its most radical time-saving measure by empowering a trial chamber to reduce the number of counts charged and to reduce the number of incidents in respect of which evidence may be led, having regard to all the relevant circumstances, but so that the remaining charges are reasonably representative of the crimes charged in the indictment. In practice, there is on average about a 1/3 reduction of the scope of the indictment in respect of each trial. The tribunal, which has the quasi-legislative power to amend the rules of procedure and evidence, has done so 47 times since the first set of rules was adopted in 1994, and this mostly in response to the need to devise strategies to expedite its work. But in what legal context was this flurry of activity taking place? against the background of what legal system were amendments made? Indeed, what is the tribunal's legal system? I have been at the tribunal long enough to recall the stinging comment of a writer in the London Times in 1999 that the tribunal is a rogue court with rigged rules, and that it dips into a potpourri of different legal systems from around the world. My view is that at base, the tribunal's legal system, as established by its statute, is common law adversarial, with an independent prosecutor responsible for the investigation and prosecution of crimes, squaring off against the accused, and the three-member bench of judges in the middle as an impartial arbiter. Now, it needs to be said immediately that with the passage of time and with a view to expediting proceedings, judges were given more powers to enable them to become more involved in trials. Generally, the collection and presentation of evidence follows the common law adversarial system, where these matters are in the hands of the parties. An independent prosecutor is responsible for the investigation and prosecution of crimes. Fact-finding and the collection of evidence is predominantly in the hands of the judge in the civil law system. On the other hand, admissibility of evidence is based on the more relaxed civil law model. Evidence is admissible so long as it is relevant and probative, making hearsay evidence admissible, whereas it is inadmissible in the common law system, though I'm very quick to say that the exceptions to that rule in the common law system are legion. We thus have the interaction of the two legal systems at the most basic level of a criminal trial. The regime for the collection and presentation of evidence, and the regime for the admissibility of evidence. Nonetheless, this interaction should not be overstated, because in practice, neither the civil nor the common law system exists in a pure form. They borrow from each other, and as has been rightly said, it is more accurate to speak of a dominant model. Now, let me mention some of the measures adopted by the tribunal in the interest of the expeditiousness of its trials. As a general rule, pursuant to Rule 89F, adopted in 2000, a chamber may receive the evidence of a witness in written form if it is in the interest of justice to do so. And I've already referred to the amendment to the rules in 2000, which allows the admission of written evidence or transcripts of previous testimony in lieu of oral evidence, provided the evidence goes to proof of a matter other than the acts and conduct of the accused. This measure, to be found in Rule 92 bis, is decidedly civil law in flavor, in contrast to the common law's predilection for the orality of evidence. An interesting feature of this measure is that it is at the discretion of the trial chamber to allow cross-examination. If allowed, cross-examination takes place in accordance with Rule 92 ter. This raises the question whether there is any detriment to the accused and his defense in not having, as is the case in common law jurisdictions, the right to determine whether to cross-examine, albeit in relation to evidence that does not go to the acts and conduct of the accused. Rule 92 ter, adopted in 2006, provides for the admission of written evidence or transcripts of previous testimony in relation to evidence that may or may not go to the acts and conduct of the accused, provided the witness is present in court, is available for cross-examination, and attests that the written evidence accurately reflects the witness's declaration and what the witness would say if examined. In 2006, Rule 92 bis C was reincorporated into the rules as Rule 92 quater to allow for the admission of written evidence of a person who has subsequently died or who can no longer with reasonable diligence be traced, or who is physically or mentally unable to testify. This evidence may or may not go to proof of acts and conduct of the accused, but when it does, this may be a factor against the admission of such evidence. Although the use of written statements in these circumstances has a civil law flavor, many common law jurisdictions have similar provisions. In 2009, Rule 92 quinquies was adopted to allow the admission of written statements or transcripts of previous testimony of a person whose non-attendance at trial is due to improper interference, such as threats, violence, and bribery. Now, the last measure I wish to mention is judicial notice. Rule 94A provides for judicial notice of facts of common knowledge not subject to reasonable dispute. This aspect of judicial notice is found in many common law jurisdictions. It has not been relied on to a very great extent in trials and has not given rise to much dispute. More controversial, however, is judicial notice of adjudicated facts from other proceedings. This is Rule 94B, and facts are considered as having been adjudicated in a previous case when they have been unchallenged on appeal or confirmed by the appeals chamber. There is then no need to lead evidence to establish this fact, and once the fact has been admitted, a rebuttable presumption arises, shifting the burden of contesting it to the other party, which is usually the accused, since in 99% of the cases, it is the prosecution that seeks to have adjudicated facts admitted. The shift resulting from this rebuttable presumption has given rise to much debate as to whether it breaches the rule that the burden of proof is on the prosecution. Nonetheless, the tribunal's case law is that there is no such breach. A great deal of evidence, usually evidence of the physical crimes, is admitted in this way from previous trials, thereby expediting the trial process. And now, the provenance of this species of judicial notice is not entirely clear. Indeed, its paternity might be said to be in dispute. But whatever DNA evidence is available would seem to suggest that it was inspired by the practice in a particular civil law jurisdiction. For a variety of reasons, it is entirely appropriate at this time to consider the legacy of the tribunal in terms of the rules of procedure and evidence it has adopted in order to expedite its trials. To begin with, the tribunal is the first of its kind since the Nuremberg Tribunal was established 66 years ago. Secondly, the consideration takes place at a time when the tribunal's procedures have already taken shape and matured. And finally, the assessment comes at a time when the tribunal is very near the completion of its work. What will future generations learn from the debate as to whether the tribunal embodies the common law adversarial or the civil law inquisitorial system. Indeed, is such a debate productive? The same question may be asked about the debate whether the tribunal system is or should be judge-driven or party-driven. Will future international criminal tribunals, or indeed current ones, or domestic criminal law systems benefit from these expediting procedures, or will they be rejected as unhelpful, unnecessary, or worse yet, as inimical to the achievement of international criminal justice? Has fairness, which must be the overriding consideration in a trial, been compromised in any way by the several procedures the tribunal has adopted to expedite trials? Have the rights of the accused been adversely affected by these procedures? Former ICTY judge and USA District Judge Patricia Wald, speaking of the increased role of written testimony in the tribunal's trials, splendidly summed up the potential collision of fairness and efficiency in a wonderfully titled article, To Establish Incredible Events by Credible Evidence, when she said, and here I quote, "Whether that trend will go so far as to offend bedrock principles of a fair trial will almost surely be litigated by defense counsel in the forthcoming trials. It is indeed an issue that deserves thoughtful consideration by international commentators and practitioners. International courts of some genre will probably exist for the foreseeable future. Their emerging body of trial practices must be regularly scrutinized to assure fundamental fairness, especially in view of the fact that they operate in isolation, not as part of a national system of courts or governmental bodies capable of oversight. At the same time, if they are to perform their unique function, such courts cannot be required to conform to a particular national code of criminal procedure. There must be due recognition that, to preserve respect, such courts must act not only fairly, but expeditiously." End of quotation. Now, ladies and gentlemen, this is the background to the three themes that I have identified for discussion. And the first theme I have described as follows. There is no fundamental principle of law that requires the tribunal to work in both the common law and civil law systems. And it would not be difficult to argue that they should work in one or the other. The considerations that have led them to work in both systems are political and not legal. I would like to explore whether the ICTY model, which draws from both the common law adversarial and the civil law inquisitorial systems, has proven to be more efficacious than the use of either one or the other system, bearing in mind the criticism that has been made that since the countries in which the conflict occurred are civil law countries, the tribunal should have used the civil law system. And the second theme I identified for discussion is as follows. The system at the tribunal is not just an amalgamation of the common and civil law systems, but one which is sui generis. Conflicts between the common law and civil law systems are resolved using the principles of fairness, and thus the system is neither party-driven nor judge-driven. It is a system that is fairness-driven. In that regard, I want to consider where it becomes irrelevant whether the tribunal system is civil or common law, because after all, Article 14 of the International Covenant on Civil and Political Rights sets out the minimum standards for a fair trial, and it is not specifically related to either system. The third theme is as follows. The tribunal has been criticized that it has employed measures to increase efficiency in order to meet its completion strategy at the expense of the rights of the accused to a fair trial. Sub-themes: what has the impact of the completion strategy been on the fairness and efficiency of the tribunal's proceedings? Have measures employed to expedite trials actually increased efficiency? Have these measures been in accordance with the object and purpose of the statute and rules to ensure a fair and expeditious trial? Have they compromised the fairness of the trials or served to further safeguard the rights of the accused? By way of example, how has the introduction of written statements in lieu of oral testimony impacted on the trial process, particularly in light of the issue of fairness to the accused? That is as much as I want to say by way of introduction. And I should say that in meeting with the panelists this morning, they all stressed that they want this discussion to be done in a way that is interactive and that affords as much time as is possible for you, the participants, to ask questions. In this sense, I think they said they want to be democratic. Not to suggest that the other panels have been undemocratic. There must be at least 1 hour for discussion. I am going to first call on Judge Gabrielle Kirk McDonald, who was a judge of this tribunal and indeed was the president of the tribunal when I came here in 1998, and who was very, very gracious to me as a newcomer. And I'm going to ask her to see what she has to say. Judge McDonald.
I'll see a little bit of it. Good. Thank you. Thank you, President Robinson, for those kind remarks. And good morning to everyone. Today, my remarks will cover 3 themes. First, what constitutes efficiency and fairness? Second, what are some of the ways we can achieve it? And third, how can we assess whether these goals have been achieved at the ICTY? I do not purport to have answers to all of these questions. I have been away from the tribunal for 12 years now. But whenever I prepare for events such as these, I am even more convinced that the tribunal will go down in history as one of the United Nations' success stories. And the reason I believe is because of the tribunal's relentless efforts and successes in achieving procedural efficiency and fairness, both for victims and for those brought before it to answer for their crimes. So first, what constitutes efficiency and fairness? The catalog of atrocities that took place in the former Yugoslavia in the mid-1990s is well known, and it's critical to keep this in mind as we frame our arguments with regards to efficiency and fairness, because these goals should be gauged by indicators wider than the tribunal's judicial operations. First, it must do justice through its trials and appeals, but it also was conceived as an instrument of peace. It was established by the Security Council, acting under its Chapter 7 powers while the conflict was ongoing, a conflict which involved mass killings, organized and systematic detention and rape of women, and ethnic cleansing. Thus, the ICTY, a judicial body, was given the ambitious mandate of not only halting the commission of these serious violations of international humanitarian law, it was also mandated to bring about and maintain international peace and security. What a tall order. I agree with President Robinson that the ICTY is a model for international criminal justice. Undoubtedly, however, there have been numerous hiccups. However, the ICTY, as well as the Rwanda Tribunal, have served as templates, and that's your word, President Robinson, as templates for other tribunals, including the International Criminal Court. I also agree with President Robinson that the first step in assessing whether the tribunal's rules and procedure and evidence meet fairness is to look to the statute, to its interpretation in accordance with the ordinary meaning of the terms provided in the document, in their context, and in light of its object and purpose. The first judges were guided by these factors when we drafted and adopted the rules. Yet I may be more open to a blending of common and civil law traditions than some, even if this fusion on its face may appear to create tension. I believe what we should apply is whether in the totality of circumstances the rules have applied for a fair trial, consistent with the sui generis nature of the ICTY, as opposed to whether they meet tests under our national perceptions. Thus, the lens through which we view concepts of efficiency and fairness should not be heavily influenced by our own legal backgrounds, but by a critical assessment of whether both accused and victim received an efficient and fair trial under international standards. 2, what are some of the ways to achieve efficiency and fairness? Undoubtedly, when the judges first met in 1993, our primary allegiance was to our own national systems. Yet we ultimately shed our tunnel vision and created an international institution. We framed rules to fit the nature of the conflict and to provide efficient and fair trials that complied with the highest standards of due process. By way of a few examples, we adopted specific evidentiary procedures recognizing the widespread and coercive nature of sexual assaults against women. Evidence of patterns of conduct not limited to the guilt or innocence of the accused was made admissible under our Rule 93. Similarly, rules for the protection of witnesses, such as protecting the identity of the witness from the public, were adopted, understanding that they may have a reluctance to appear. The only exception to our preference for live testimony was to allow testimony by deposition, where cross-examination was preserved. The question of whether the tribunal could hold trials in absentia was passionately debated among the judges, and those of us who came out against it carried the argument. And at this time, I might pause, because yesterday there were many remembrances of President Antonio Cassese. What no one told you was that Nino was a prize fighter, and he and I went 15 rounds. I against trials in absentia, he in favor. He suffered a TKO at my hands, but he didn't go down for the count, because, as we know, Nino had an intensity and a perseverance. And what happened? Trials in absentia reappeared at the Lebanon Tribunal, where he was president. So that's one of my memories of Nino. Now let me speak about amendments to expedite trials. The rules of procedure and evidence, however, have undergone a total of 47, President Robinson said a few minutes ago, amendments. The last one occurred on October 28th. The vast majority of these amendments were made following careful assessments by judges, the prosecution, and defense counsel. But the rules have been amended for other reasons, essentially in response to external pressures, including by the United Nations. These amendments enabled the tribunal, at least some of them, to achieve increased efficiency and fairness in trials. But they also have been the subject of severe criticism. I have disagreements with those critics, most of whom hail from common law traditions, who base their criticisms, especially of the 2000 amendments, as a turn from earlier emphasis on the principle of orality. And as one former judge, who President Robinson cited, Judge Wall, put it, a departure from common law rules of evidence. I wonder, though, if these critics know that the United States, whose legal system is founded on the common law tradition, itself proposed in 1993, when we first met, a rule allowing the admission of written statements in lieu of oral testimony, which, however, was bereft of the factors that are now contained in Rule 92 bis. The first judges, however, declined to accept this proposal. While it is indeed true that the amendments on their face circumscribe the principle of orality, what is undeniable is that in practice, live testimony remains predominant at the ICTY. A review of the tribunal's decisions relating to efforts to introduce evidence under 92 bis and terror shows that the trial and appeals chamber judges carefully weigh both efficiency of the proceedings and fairness to the accused before allowing for the introduction of such evidence. It is important to note that the cases before the tribunal are highly fact-intensive and span long periods of time, and President Robinson has made a reference to the Milosevic case. That case involved crimes occurring from 1991 through 1999 in 3 different conflicts, and it was originally estimated that there would be 380 to 600 witnesses anticipated. Therefore, admitting written testimony following a careful analysis of the factors provided in Rule 92 bis, especially redundancy, can speed up proceedings considerably and save significant costs associated with the task of documenting and adjudicating these mass crimes. Another consideration, however, that should be taken into account is whether the amendments violate Article 21 of the statute, which among other things incorporates the guarantees of Article 14 of the International Covenant for Civil and Political Rights, providing for the right to cross-examine witnesses. Based on my review of the ICTY's jurisprudence, in the totality of the circumstances, the tribunal has succeeded in making the trials much more efficient without sacrificing the due process rights of the accused. The urgency the tribunal now feels was brought to bear by the UN. The completion strategy was designed to reduce costs and close shop. Concerns about the right of the accused to be tried without undue delay and even the length of detentions has now been replaced by tribunal fatigue, the high cost of international justice. Such pressure to provide speedy trials that is not motivated by concern for the rights of the accused can threaten the integrity of the proceedings and may even damage the credibility of the ICTY. This is the threat to fairness of the trials, even more than the progeny of the particular rule. Perhaps now, some 16 years after the Dayton Accords, the obsession with expeditiousness should be re-examined, particularly when persons alleged to have been the major actors in the conflict are now in detention. And the ICC, which has learned so many lessons from the ICTY, should reject this short-sightedness. What matters I've lost my place here. I have scribbled all over this, and I can't read my own writing yet. Let me get to the third point. So how do we assess whether these goals have been achieved? And this brings me to my final point. We can spend decades debating the comparative fairness of the common and civil law systems. What matters, however, is whether the ICTY has succeeded in meting out its mandate. Has it made an impact on the affected populations? One of the goals has been met. The widespread killings, rapes, and other forms of sexual violence, detention, and expulsion have been halted. Significant movement has been made towards establishing more than a cessation of hostilities. Real progress has been made for a lasting peace. And we heard yesterday from Diane Ortlicker that the Bosnians she interviewed felt thankful for the tribunal. They felt that without it, they would not have received justice. The impact of the trials that are broadcast in the region cannot be overstated. Trials enhance the perceptions of the tribunal's fairness and help deter future atrocities by educating the population about what occurred through the use of testimony and evidence that they themselves can view and assess. Trials show the rule of law is the best way to hold accountable those who violate international humanitarian law. The outreach program reinforces this process. In the early 90s, as horror was being visited on the people of the former Yugoslavia, the international community was stymied by inaction and a lack of agreement about what to do, if anything. The ICTY was born out of this uncertainty. When the first judges arrived in The Hague, we had practically nothing. We had no budget and received monthly allotments, making it difficult to hire staff. We even had no premises, including a courtroom or detention unit. And George Abisab was here yesterday. I remember, there you are. You remember, George, when Nino and you and I came to visit what was then the Aegon Insurance Building. And that's where we ultimately settled. So we had no place to hang our hat. What we also critically lacked was a way to bring indicted persons to the tribunal. The multinational peacekeeping force failed to intercede, claiming its mandate was to keep the parties apart and not to arrest persons indicted by the tribunal. Indeed, not a single indictee was arrested and transferred to the tribunal until July 1997, some 4 years after our establishment. The 11 judges who adopted the rules in 1994 operated in this uncertain reality. So finally, there are sound reasons for demanding that complex international trials be efficient. Yet there are compelling reasons for providing a process which places a greater emphasis on making sure that the tribunal gets it right, that it delivers justice regardless of the time that it takes. In my opinion, this is the most important benchmark to assess whether our efforts at efficiency and fairness were successful. Did we get it right? I think we did. Thank you. Thank you, Mr. President.
Thank you very much, Judge McDonald. I now ask Professor Claus Kress to speak.